million naira in compensatory damages against the Kenyan government for its role in the unlawful abduction and rendition. Justice Isinwita said directly, having considered the pleadings and arguments by both parties, the decision I relied on are the Constitution and the law. I come to the following conclusions. Firstly, the government of Kenya violated the Constitution and Mr. Nnamdi Kanu's rights and fundamental freedoms. Having entered Kenya lawfully, he was subject to the protection offered by the Constitution of Kenya 2010. And the government of Kenya had an obligation to uphold and protect his rights and fundamental freedoms. Mr. Nnamdi Kanu was, however, abducted, kept in solitary confinement, tortured, and denied food and medication, a breach of basic rights. He was chained, humiliated, ridiculed, and held in contempt, and later forcibly removed from Kenya without following the law, in violation of his rights and fundamental freedoms for which the government of Kenya is liable. Jesus. Hey, thank you, Lord. Based on the above conclusions, the court makes the following declarations as orders. It considers appropriate. A declaration is hereby issued that the abduction of Mr. Nnamdi Kanu, holding him in incommunicado confinement, torturing him, and denying him food, water, medication, and other basic necessities was a violation of his rights and fundamental freedoms. A declaration is hereby issued that the abduction and subsequent forcible removal of Nnamdi Kanu from Kenya to Nigeria was in violation of the laws of Kenya, his rights and fundamental freedoms, including freedom of movement, freedom of security of the person guaranteed by the Constitution of Kenya 2010, and therefore unconstitutional and illegal. Listen, we are still on. An order for compensation is hereby issued, awarding Mr. Nnamdi Kanu general damages of 10 million Kenyan shillings, which is 120 million naira, against the Attorney General of Kenya and the government of Kenya on behalf of the federal government of Kenya for the violation of Mr. Nnamdi Kanu's constitutional rights and fundamental freedoms. This is the judgment of the courts of Kenya. And doesn't it ring a bell? Remember that a high court sitting in Abia State gave a judgment like this for Nnamdi Kanu. Yes, gave a judgment that a compensation be made to Nnamdi Kanu. You see that a good court is a good court. So you see that judgment and these judgments in Kenya look very similar. So whatever they have been doing in that Justice Binta Nyako's court was just a charade. Let's go on, because after that judgment was given, the IPOB brought out a statement, and this is what the IPOB said, the indigenous people of Biafra. So meanwhile, the IPOB has hailed the judgment as a landmark victory, saying that it vindicates the group's long-standing position since what it described as the sham and partial trial of its leader in Nigeria. A statement signed by the IPOB spokesperson, Ima Powerful, said, as he read, "The indigenous people of Biafra wishes to formally announce a resounding judicial earthquake that has shaken the legal foundations of the fraudulent rendition of our leader, Onyendu Mazi Nnamdi Kanu. In a historic, courageous, and landmark judgment delivered on June 14th, 2025, the High Court in Kenya, sitting in Nairobi, found that the abduction, incommunicado detention, torture, and illegal transfer of Mazi Nnamdi Kanu from Kenya to Nigeria in June 2021 was unlawful, unconstitutional, and a gross violation of his fundamental human rights under Kenyan and international law. This judgment vindicates our consistent position that what transpired in Nairobi, Kenya in June 2021 was not extradition but an extraordinary rendition. It was a criminal act of state-sponsored international terrorism involving the highest authorities of the Nigerian and Kenyan governments. We are grateful beyond measure to the brilliant legal leadership of Professor P.L.O. Lumumba, lead counsel in the Kenyan litigation, whose courage, clarity, and tenacity led to this monumental legal victory. IPOB also extends heartfelt appreciation to Kenyan judiciary, especially Honorable Justice E.C. Mwita, who stood tall against ferocious political interference and international diplomatic pressure to deliver a fearless judgment grounded in law, morality, and constitutional justice. We know, and now, the world must acknowledge that Mazi Nnamdi Kanu did not commit any crime in Kenya. He entered Kenya lawfully as a British citizen. He was abducted in broad daylight at Jomo Kenyatta International Airport by agents of Nigeria's secret police in collusion with rogue elements of the Kenyan security apparatus. He was chained, tortured, denied medication, and eventually bundled onto a private jet and flown illegally to Abuja without any extradition hearing or judicial warrant. This verdict places a permanent and indelible legal stain on the records of former Presidents Uhuru Kenyatta of Kenya, Muhammadu Buhari of Nigeria, and former Attorney General of Nigeria, Abubakar Malami, and their accomplices. It also exposes the criminal lobbying missions embarked upon by Nigerian leaders, from Buhari, Osinbajo, to Tinubu and Shetima, all of whom tried and failed to manipulate Kenya's judiciary to cover up this internationally condemned act of extraordinary rendition. Let it be known that this is not the end. This is just the beginning of a global accountability campaign. All those responsible in Kenya, Nigeria, or elsewhere shall be pursued to the ends of the earth under the universal principle of accountability for crimes against humanity. Neither the British diplomatic complicity nor cowardly silence from Western powers will shield the perpetrators from the legal, diplomatic, and moral reckoning that is coming for them. To Justice E.C. Mwita, we say, thank you for your judicial bravery. To Professor P.L.O. Lumumba and his legal team. We salute you, sir. We also salute your exceptional advocacy. Now, to all the oppressed people of the world, this is your victory. Also, a warning to tyrants that international borders will no longer shield criminals and criminal regimes from justice. That is it. Clear case of justice well served. How do you think you can come to a country and perform such criminal acts and go free of charge? It's just a matter of time. I don't know why the United Nations have not yet said anything about it. Look at a whole UN. Are they going to pretend they don't know that such an act happened in a country of kidnap